Okay, we're going to move on. We're going to start the afternoon portion of the session. So now that we have spent the morning and the lunch session discussing an outside look at systems approaches in other industries, and we've gotten, I think, some very useful vocabulary and thought about some of the unifying concepts of a systems approach that might be applied to criminal justice. I think we're in a good position now to turn our attention a little bit more inward to how innovative and progressive criminal justice practitioners are approaching quality control and safety and helping their own portions of the system work more effectively. And I'm very excited to have four panelists here to talk about quality control in a prosecutor's office, quality control in a public defender's office, quality control from a law enforcement perspective, and then an innovative approach to quality control with our local and county court systems. So each of the speakers that we have will be approaching this from a different segment of the criminal justice system, but I would encourage you to be thinking about the concepts and discussions that we had in the morning and how those might apply to evaluations and questions that you might ask these panelists when we get to the Q&A period. So I'm going to introduce the panelists, and the format is really the same as this morning. Each panelist will speak for a few minutes, and probably in the 7 to 10 minute arena. I may give you the high sign at some point when we get close to that, and then we will leave the rest of the time available for your questions. And so I'd like to introduce the panelists. I'm going to introduce them in alphabetical order, but then we're going to change the order in which we go. So first is Jeff Adachi, who is the public defender of the city of San Francisco. He is let me make sure I say this right. When I say he's the largest elected public defender in the country, it sounds funny. He's the elected public defender who has the largest office. Is that right?
Yeah.
Okay. He may also be the largest elected public defender, I'm not sure. Mr. Adachi worked as the deputy public defender in San Francisco for 15 years and was in private practice for 2 years. From 1998 to 2001, he was the chief attorney of the public defender's office. He's tried over 150 jury trials, including a number of serious felony and homicide cases, and has handled over 3,000 criminal matters in his career, including some of the Bay Area's highest profile cases. He's a graduate of the University of California, Berkeley, and the Hastings College of Law, from which he graduated in 1985. Amy Bach is the executive director of Measures for Justice, which she founded in 2011 as a follow-up to her book, Ordinary Injustice, How America Holds Court, which won the 2010 Robert F. Kennedy Book Award. Just on a personal level, if you haven't read Ordinary Injustice, you really should. It's a great read, it's very well written, and it provides a really in-depth and interesting look at how justice really happens in local court systems. Amy is a 2011 Echoing Green Fellow, and for her work on Ordinary Injustice, she received a Soros Media Fellowship, a special J. Anthony Lucas citation, and a Radcliffe Fellowship. She was a Knight Foundation Journalism Fellow at Yale Law School and is a graduate of Stanford Law, and she's a research scholar at the Institute for the Study of Judiciary, Politics, and the Media at Syracuse University. To her right is Karen Amendola, Chief Behavioral Scientist with the Police Foundation, where she's worked with the Police Foundation for more than 20 years, previously as the Chief Operating Officer. Dr. Amendola earned both her PhD and her MA in Industrial and Organizational Psychology from George Mason University, and has worked with dozens of local, state, and federal agencies across the United States and abroad. She was recently the Associate Editor for Psychology and Law for the 2014 Encyclopedia of Criminology and Criminal Justice. And she's been a principal investigator on recent research studies in criminal justice interpretations of evidentiary strength and eyewitness identification in criminal cases. With her colleagues, Dr. Amendola has earned the prestigious 2012 Outstanding Field Trial Award from the Division of Experimental Criminology of the American Society of Criminology for her experimental study on the influence of shift length on a variety of outcomes. And last, alphabetically, is the Honorable Craig Watkins, the District Attorney in Dallas County, Texas. Craig Watkins was elected the District Attorney in Dallas County in November 2006 and is therefore the first African-American District Attorney in Texas. Since then, his steadfast commitment to the integrity of criminal justice in Dallas has garnered national and international attention. He's the creator of the first Convictions Integrity Unit in the United States, and I think one way to measure success is, flattery or imitation is the sincerest form of flattery, and a number of Convictions Integrity Units have sprouted up in different DA's offices around the country, which is proof of the impact of Craig starting it in Dallas. The Dallas Convictions Integrity Unit has reviewed more than 400 cases and helped free 33 wrongfully convicted inmates. Mr. Watkins is a graduate of Prairie View A&M and later earned his law degree from Texas Wesleyan University in Fort Worth. So I've introduced in alphabetical order, but I think what we're going to do is DA, defender, law enforcement, courts. So we'll start with Craig.
All right. First of all, I want to thank the Quattrone Center for inviting me again. This is my second. I think this is the second conference. Am I right?
We had a soft launch.
A soft launch? Okay. This is the second one I've been at, and I am thoroughly impressed with the things that I've learned over the two conferences. And we have a wealth of knowledge that we're going to take back to Dallas. I have two of my top assistants, Russell Wilson there and David Alex back there, who are with me. So we can take all of the information that we're learning here back to the Dallas County District Attorney's Office. So I get the distinction of starting a conviction integrity unit, which is basically gone throughout the country as the way you prosecute cases. But I want to be honest with you. When I got elected, I was not thinking about a conviction integrity unit. I got elected and I brought into the office a very emotional approach to how criminal justice should be dispensed in Texas because of my experience as an African American. I didn't trust law enforcement, never did, still don't. And I knew that. But you are the man. Yes. That we needed to change the culture of not only prosecution but policing and how we deal with certain issues to make our criminal justice system live up to the founding fathers who obviously started here in this city, who wrote the Constitution, to live up to what they wrote in that Constitution all those years ago as to what it means to be an American. And so in my first day in office, or my first week, I think it was my second day in office, when I was running for election, there was this case that had been lingering for 5 years. And the person that I was running against was a current assistant DA. He was taking the place of the elected DA. He was the front runner. And obviously they didn't want to have an issue of a person that had been wrongfully convicted on the front page of the newspaper right before the election. And so they waited until after the election to have this person freed for something that he didn't do. And fortunately for me, it was my second day in office that the court decided to go ahead and push forward this exoneration. And so I went down to the courtroom. There was maybe one reporter in there. You know, it was a clear courtroom. No one's in there. The guy walked out of the holding cell and was very surprised when he walked out to the light of the courtroom and to see the elected DA there. And I went and shook his hand and I apologized to him for being convicted for something he didn't do. The next day it was on the front page of the newspaper, and not only the newspaper in Dallas, but the New York Times, the Washington Post, pretty much every major newspaper that an elected DA went down and apologized to someone for being wrongfully convicted. And then soon after that, I don't know if you remember this, Barry, but someone from your office came to my office and basically suggested that we start a unit. The conviction integrity name wasn't there, but that we proactively look at cases of innocence. And to be honest with you, I am the first African-American district attorney in the state of Texas. I am not experienced, and I shouldn't be there. And politically, is that the right move for me? To basically free people of color for something they didn't do, to free individuals, to say to those individuals who just elected me to put people in jail in their minds, to convict people, to provide safety for the citizens of Dallas County. You're asking me to go out on a limb when I'm trying to gain credibility as this new DA. I was only 38 years old when I got elected, and I'm young and I'm African American and I'm 38, and now you want me to go and free people, but I'm the DA, I'm supposed to put people in jail. And so it took me, I had to think about it a couple of days. I had to think about it, and I look back on that, and before I went through an election cycle and I went through the difficulties of getting elected and dealing with the scrutiny, I was fearless. My biggest regret was the fact that I had to actually think about it. I had to think about it. And I said ever since then, after we did it, that I would never, ever be afraid to do what's right. And so we put the Conviction Integrity Unit in place, and unfortunately for our system, since 2008, when we put it in place, we have exonerated 33 individuals. I say that's unfortunate for our system because that says something about our system. It needs to be fixed. And not fixed only from the standpoint of wrongful convictions, but also fixed from the standpoint of how do we dispense justice to make sure that we get a cost-benefit result at the end of the day. On the front page, when we exonerate someone, yes, we'll see, we'll get a lot of media coverage for someone that went to prison for something they didn't do, but the larger question is when we do convict someone that committed a crime, and that person is convicted and they come back to our communities after they're convicted and they spend time in prison, what result are we getting? How do we fix that? How do we look at this in the guy from the NTSB hit it right on the head. How do we make our system work as it should? Because as a DA, my role is to make sure that we protect the citizens of Dallas County, that we get a benefit from our criminal justice system. And so the majority of the individuals that go through the system are guilty. They committed a crime. But at the end of the day, as a DA of Dallas County, what can I do when I do have to take a person's freedom and convict them and even send them to prison for a time? What do we get as a result of that? What are we getting? And what we've gotten over the years is a person that becomes a habitual criminal, a person that's an aberration in our society that makes more victims. And so as a DA, my role is to look at the system to say that, first of all, we've convicted innocent individuals for something they didn't do. Secondly, we convict people, we send them, we punish them, but we don't get a result we don't get a result from that punishment. They come back, they're going to live on my street, they're going to live on your street, they're coming back to my communities. And so as a result of the taxpayer dollars that we're spending to deal with these individuals, what are we getting? And as a business individual, you want a return on your investment. In Texas, we spend about $60 a day to imprison a person for a crime. And largely those individuals will be released at some point. What are we getting as a result of spending $60 per day to incarcerate that individuals? What are we getting back when they get out of prison? And we don't have anything to say for it. We're not getting anything back. We're getting something worse back than what we sent to prison. They have actually learned how to be better criminals, to be an aberration to our society, to wreak havoc on law-abiding citizens when they go to prison. And basically, we've paid for their training. And so the question I have and that we're pushing forward from the Dallas County District Attorney's Office is that we want to be the leaders of reforming the criminal justice system. And we're looking at a lot of issues. And a lot of things have been brought to my attention here that correlate with some of the things that we want to do in Dallas that are very important, and I would love, that first panel, I would love to have those people come down to Dallas and just sit and do the same thing they did here and talk to my prosecutors so they can understand that this is not just about winning. This is not just about prosecutions. This is not just about being tough on crime. We need to change the culture and see and look at this from the standpoint of what can we do to improve the system, to make it work, because we don't want to be victims of crime. And when we have to deal with victims of crime, that's not a win. As prosecutors, as elected prosecutors, unfortunately, we run on the fact that we convicted someone. Our conviction rate is almost 100%, or we sent this, violent individual to prison for a long time, but what good does that do us? What good does that do us when we actually are basically, we're basically saying to our constituents that we're there as a cleanup man. Well, we are waiting for a crime to be committed, and we jump up for joy that we get to prosecute them, and unfortunately there's a victim as a result of that. And so the idea as the DA, the elected official, it's not to be in a courtroom, it's not to stand in front of a jury like we see Perry Mason. It's more of to set policy that makes the citizens that we represent safer. And this institution basically is giving us the tools to look at that, to see what we can do to implement those policies within our own offices. And unfortunately, I have the second largest DA's office in Texas and the 8th in the country. So we can go back and institute what we're learning here to make prosecution better. You gave me a 2-minute sign, so I think I'm at 30 seconds, and I'd love to answer any of your questions in a few minutes. Thank you.
Good afternoon, everyone. I am so very honored to be here. And if we had more elected district attorneys like Craig Watkins, that'd be a big step towards reform. And I feel, in a sense, like I've died and woke up in heaven here. This is like the Oscars of folks who have fought for justice. Barry Scheck, I met Michael Morton yesterday, who was exonerated after 25 years. And if you have a chance to see his film, An Unreal Dream, it's probably the best film on a person who's been exonerated, so make sure you check it out. I want to thank the Quattrones and John for including a public defender in this discussion. I think there are a couple of us here, because public defenders are often treated as the stepchild of the system. I think out of every dollar that is spent on criminal justice, about 5 cents goes to the public defender. And I used to sit on the standing committee for legal aid and indigent defense for the American Bar Association, and you see the same thing everywhere. Public defender offices are understaffed, underfunded. They have these huge caseloads. Today, there are public defenders who are handling as many as 500 felony cases a year. You think about that. Take everyone in this room, multiply it by 3, and that's the number of people that you're responsible for, charged with serious crimes. And that's the reality that we face as public defenders in this country. It's not like that everywhere. I met the public defender of the UK, and, I was talking to him about how they do it there, and he goes, well, when in the UK, you have a right to a lawyer, and you can go to any lawyer you want, and, we pay the bill. And I said, well, isn't that expensive? He said, yeah, it costs, about 3 times what we pay to prosecute people. And I was like, wow, so what do people have to say about it? Oh, the prosecutors are always complaining, but that's the way we do it in this country, And so it's not the way that we do it here everywhere. And certainly, I think one of the biggest things that we need in terms of reform is to properly fund public defender's office. When I came into the San Francisco Public Defender, 11 years ago, our budget was 13 million. Today it's about 29 million. It's still not enough. But we got that by fighting for more resources and declining cases. And I'm elected, and I'm the only elected public defender in California. Everybody else is appointed. And so what happens is that if the public defender declines cases or, protests their budget, they get fired. And that's a reality in most places. We're not on equal footing with the district attorneys. So, anyways, I'm here today to talk about checklists. Exciting subject after lunch. And the book, The Checklist Manifesto by Dr. Atul Gawande, was a gift that was given to me, and one of my friends gave it to me. He said, hey, read this. And of course, it just sat on my shelf for a while. And then 6 months later, I saw him. He said, did you read the book? I said, no, I haven't read it. I don't want to read a book about checklists. He goes, read it. And I did. It's not a very thick book, but it's written by a Boston surgeon and Harvard professor who talks about, in the medical profession, as we were discussing this morning, how many people die every year just because simple procedures are not followed. And the thing that struck me most about the book, and it took me a little while to adopt it, because we don't want to believe as professionals or as lawyers that you can reduce what we do, our talent, our judgment, our experience, into a checklist. But the reality is, if you don't, you run the risk of making a mistake that can prove fatal to your case, fatal to your client, because we do deal with life and liberty each and every day. And I run an office of 92 attorneys and 80 support staff. And so by the time problems get to my desk, they're pretty big problems. A lawyer is in trouble with the state bar. There's a complaint by the client or his or her family. And what I began realizing is that in looking at how these problems occur, had we used a checklist, most of these problems were preventable. And so that was sort of the genesis for trying to see, can we apply what Dr. Gawande says in the Checklist Manifesto to what we do each and every day as public defenders. Now, who wants to use a checklist? Usually nobody. Why? Because a checklist is seen as, something sort of cold and remote. And, we like to think that we know how to do everything. And it's true. You might know how to do it. You might be an expert in a particular field or area. You're doing, a particular type of case. But that doesn't mean that you're not going to make a mistake. Think about, as criminal defense attorneys, all the responsibilities we have, all the tasks we have, all the motions you could file, all of the different things that you have to do in order to properly defend a person accused of a crime. It doesn't matter whether it's a misdemeanor or a felony or death penalty case. I mean, there are literally hundreds and hundreds of things that we're responsible for. And so using a checklist ensures that we're doing everything that we should be doing. And it's impossible, virtually impossible, to know off the top of your head in every situation what to do, no matter how experienced you are. The big question, though, is, how do you apply it to what we do? Because we have so many responsibilities. How do we juggle all the things? And so we started looking at what are the things that we most commonly do as public defenders. And I only have a few minutes, so I'm not going to go into this in any detail, but I just wanted to show you what we came up with as sort of a baseline to use these checklists. This is what's called a Frank's motion. This is a motion to determine whether or not a police officer has made misrepresentations or omissions in an affidavit. Pretty important stuff, right? People ask, what do you do as public defenders? It's our job. We get paid by the government to fight the government. And in doing these motions, we're the only agency that's looking out to make sure that officers are not committing perjury in filing affidavits. So again, these are the steps that you go through. We, for a year, had a police misconduct unit in the office, or our expert in police misconduct put together this checklist. And what's great about a checklist is that you can use it for training purposes too, right? Because somebody comes in your office, hey, how do I do one of those motions? You got to sit down and explain it. And it takes time. If you have a checklist, you can give it to the person, And these checklists are high-level checklists, and so it doesn't mean that they're necessarily going to know how to do it, but at least they'll know how to go about it, where the issues are. This is a basic motion to suppress. And again, if you don't file a motion to suppress where there is a valid motion, again, it can make the difference between winning a dismissal or not. This is a very simple DUI case workup. Do you know, in following this, one of the things that we do is we look at all of the calibration records for the preliminary alcohol screening devices that they have you blow into. And you know what we found out? That the San Francisco Police Department had not calibrated their machines for over a year. And they had misrepresented in court that they had been calibrating these machines every 90 days. So that was a huge issue. Immigration, post Padilla, when the Supreme Court has held that defense counsel have an affirmative obligation to advise clients of the immigration consequences, is huge. And it can make the difference between a person being deported or not. So we actually have 6 different lists that cover various immigration consequences, but this is an absolute must. And again, these checklists look complicated because the law is complicated, but these are the questions that need to be asked if you're considering a plea and you have a client who's not a citizen. Investigation is huge, and we use these checklists not, sort of as robotic, directions to our investigators. Each case is unique, but it gives you a starting place. For example, an eyewitness interview checklist, and you never know what is going to come of it. I mean, we had a situation in San Francisco. We had clients who were reporting that the police were barging into the rooms without warrants. And of course, we'd bring it to the judge, and the judge would believe the police officer who said, "Oh yeah, we knocked on the door, and the person invited us in, and we found drugs on the bedroom counter." And so we sent an investigator back to the hotel to see if there was any video, and she found that there was a very high-quality surveillance video in the apartment complex. And we were able to download 1.5 years, worth of video. And from that, we took every incident where there was an arrest, and we compared the police report, which was filed under penalty of perjury, against the video. And every time, it showed that the police were lying, that they, were essentially committing perjury. And so we took the video, we released it week by week, because we had 6 different videos on our YouTube channel, and by the weekend, it was on CNN. And as a result, 6 police officers so far have been indicted by the federal government for lying and perjury. So you never know, and one of the things we have on our checklist is getting the videotape. When you're working in teams, and we talked about this earlier, it's important for everybody on the team to understand what the responsibilities are. Here's a checklist we have for our juvenile paralegal. We have one for our social workers in our office, so everybody knows what everyone else is doing. You can look at this as like you're ordering at a menu and figure out what is it that the social worker can do that can help me in my case. Ever watch that TV show, The First 48? And they show you what homicide inspectors do in the first 48 hours after they begin investigating a homicide case. This is our first 30 days in a homicide case. And so we have this checklist which sets forth all of the things that you should at least consider in doing a homicide case. And again, even though you're an expert at a homicide case, maybe you tried many, many cases, you're not necessarily going to understand or even comprehend everything that you need to do and prioritize it. And sometimes people will say, "God, look at this list, it's so long. Looking at the list gives me a headache." But the reality is these are all things that you should consider. And even if you can't do all of these things, at least prioritize it in some way, so you're able to figure out, what you need to do first. Because not doing one thing, not preserving the evidence, not going to the scene, not photographing something, can cost you big time later. DNA is a huge area, of course, and these are our checklist for a DNA case. And what's good is that we have it linked to the various resources. So if you want a discovery letter, if you need to, request the DNA package from the crime lab, you're able to do that. And this is also important because you're holding the government agency accountable. And so by making sure that that agency is providing you everything that you're entitled to, you're making sure that they're doing their jobs as well. forensic cases. This is our checklist for a fingerprint case. And, we have now, I think, about 50 checklists that we use in our office. And the way that we develop the checklist is we put together a committee within our office. And, we use the collective experience of the attorneys in the office, and we assign them various checklists. And there are basically 3 steps to developing a checklist. First is to develop the checklist. The second is to draft it. And so we had a committee that actually drafted them after they were submitted by the attorneys. And then the third step is the most important, is that you have to validate it and make sure that it works and revise it. And that's a very important process, because you don't want to create a checklist that really, has no utility for the users. And, we're hoping that we can create a checklist revolution. I've given presentations in about 8 states so far, talking about checklists, because this is a way that we can improve what we do as public defenders without necessarily the resources in order to do it. And I'd like to point out to folks who say, there's no way that we could do this because, we don't have the capacity to. If you're not doing this, you are really committing malpractice. And more importantly, if you can use these checklists to explain and justify to your funders that this is what you need to do in cases, this is the only way we're going to be able to quantify our work. You can't just say, well, this is a tough case, this is an easy case. You need to be able to quantify it, and that's really what this does. Along with case weighting, looking at caseload standards, a big part of it is making sure that we can both quantify and qualify what we do. Because it's not only obviously doing the things that are on this list, but the quality that we do, the work that we do. And so I'd be happy to talk to you, more about our checklist approach. I'm very excited. We got a grant from all agencies from the Department of Justice to basically develop this. We're going to be working at it with 2 public defender offices, my office and the Alameda Public Defender's Office, and they're actually going to do sort of a control experiment where they'll look at one group of attorneys who are using the checklist and one group who are not. And so that'll be very interesting to see what impact that has on the outcomes. Thank you.
Hi, everybody. Very happy to be here, and good to see everybody trying to stay awake after lunch. I wanted to, hi back there. I wanted to follow a little bit up on the lunch speech by Chris Hart on accidents in aviation. Back in grad school, I worked with a UC Berkeley professor who had come to George Mason and was studying human factors and cockpit design and that kind of thing, and we learned about the little button that was missed during the one flight. And I just wanted to talk briefly about something that I think is really relevant for policing, which is sort of the front end of all of this discussion about error. And that would be error, well, first of all, it's, the idea of culture is one that we don't necessarily address that thoroughly across disciplines. But it goes back a long time. If you think about aviation, one of the classic accidents, and again to bring you down memory lane with your favorite airplane disaster, but the one of Air Florida flight, I can't remember the number, but this was the one in Washington, D.C. that crashed into the Potomac in the icy waters, and some people were working to save others and ended up drowning in the process or freezing to death, etc. It was a really bad crisis. I think that was 79 or in the 80s. Nevertheless, one of the main findings of that investigation was that there was human error, and the human error in this was that the ice was building up on the wings and they sat to take off, and the co-pilot mentioned to the pilot that we need to de-ice again, and he said, no, we're fine. So then, as they're waiting longer, he said, I think we're heavy. And the pilot basically brushed him off because he's a co-pilot and said, no, we're fine. And then I think there was a third comment, but somebody can correct me if I'm wrong, but it was, we're heavy. And the next thing you hear is them taking off and crashing into the Potomac because they were heavy. And so this points out a really interesting aspect of culture, which is that we follow the leader. So the problem with that is that we have to lead from the bottom up as well as the top down. So I think here, this really points out really the theme of what I would like to talk about, which is really where the police have gone with these issues over time, how they deal with their investigative processes, and where we're at today with regard to investigative processes. And I will say that just as a theme, culture is prominent everywhere. So today, I was so thrilled to know that we were being directed to lunch, and every corner we turned around, somebody directed us. And then I realized on the way back, I don't know where the hell I'm going, because there's nobody directing us back, right? So imagine that in aviation. You teach the pilot how to get up to an altitude, but you don't teach them how to land, and how to really examine the last part of the situation, which is the most important.
You're here.
Yes, I'm here. And I don't worry about flight because I studied flight in college. I worry about drivers. But nevertheless, this is a really important thing in policing, as it has been in so many of the industries that have grappled with this. In medicine, of course, a nurse is not going to question a doctor. And these were things that all these industries have grappled with. But we really haven't grappled with it in policing. And therefore, we're at a stage now where we need some new approaches to how we look at this. Because over the years, a big question in policing that's come up a lot, and not necessarily from within the police, but outside of the police, is who is policing the police? And by and large, get down to it, today, we're still at the same place. The police are policing the police. So this is, in essence, the issue of culture. And how do we get sort of past that? Okay, so the traditional approach to police investigation is that we do internal investigations, and they're generally punitive in nature. And I've always liked to say over the years that really internal affairs is such a terrible term, because what it says to the community is, this is our affair, it's none of your business. As opposed to, it really ought to be external affairs, because now we're learning with accountability that accountability is really about transparency. And again, I have to emphasize the police culture, because in many of these other industries that we've heard from and that we've learned about over the years, policing is really behind them in many of these ways, advanced in certain ways and not very advanced in other ways. And so we're only beginning this discussion. But I think that this traditional focus on internal investigation is somewhat problematic. So if we're talking about community policing, which is pretty much the model that's adapted across the U.S., we're talking about engaging communities and working to solve problems collectively. And yet when it comes to something like this, because litigation is such an issue, and because blame and fault are always at the central core of this, we really have to think about this as being a more collective process. And that is not part of police culture today. There's been a lot of other kinds of models, civilian oversight of police. Some of those organizations have some teeth, so to speak, others have none, and so it doesn't necessarily get us that far, these different options for models for that. And then we have things like DOJ investigations. My colleague here has been on many of the teams to investigate wrongdoing under patterns and practices litigation through the Civil Rights Department at Justice. And in these types of investigations, we know that the feds have teeth in them, in that they can deny funding to any law enforcement agency that engages in a pattern or practice of a wrongdoing. But nevertheless, that does not guarantee that we're going to have integrity in our investigative process. And so I think that one of the key scientists in criminology is John Eck, and a few years back he really said that past research has focused on really the police being the ones to gather the evidence, but not necessarily to appropriately interpret it and to validate it. And so we leave that to the rest of the system. And so we find a lot of investigative errors, and these have been studied in many places and for a number of years, 3 decades or more. False confessions, Richard Leo, I don't even have dates because he's written so much in the area of false confessions. Tunnel vision and cognitive biases so so strongly brought to the forefront by many social psychologists and brought out as a criminal investigative matter by Kim Rossmo, who was a former director of research at the Police Foundation from where I'm coming. And he has really focused on those kind of biases and how to train officers on how to avoid them. But there's others. Snook and Cullen recently also wrote an article in Kim Rossmo's book on criminal investigative failures and noted that that actually these biases, these cognitive shortcuts, and that type of thing, tunnel visioning, may not in fact be the cause of all error and may actually be adaptive in many ways in terms of resources. So we don't know as much as we would like to know. But we do know that evidence gets misinterpreted. I've been working on and finishing up a study on eyewitness identifications in Austin, Texas. And one of the things that we learned just anecdotally from doing this study in Austin and previously in Charlotte, North Carolina, was that when we brought prosecutors, defense, police, and prosecutors, defense, lawyers, and judges all to the table to look at cases, they weren't on the same page in the way that they interpreted evidence, even down to the basic thing of understanding what a mugshot photo is. We had police saying, "Why do you think this guy has criminal history?" And the others would say, "Well, there's a mugshot photo in the file." And the cop said, "That's not a mugshot photo, that's a DMV photo." And I thought, wow, this is really telling. They're not even on the same page necessarily. So we know all of these kinds of things, and misidentification really are the culprit here. But what Rossmo said in his book on criminal investigative failures, which, by the way, he's one of the only people that's really looked at this issue in policing, he said that the absence of a systematic approach to investigations in wrongful conviction is really what is the problem. It's certainly correlated with most wrongful convictions. So I think it's important, and in terms of accountability, what we've often done in policing is we've done after-action reporting. So, for example, the Police Foundation, after the Rodney King beating in LA and the civil disturbances that emerged, Judge Webster, the former CIA and FBI director, who was our board, our chairman of the board, and Hubert Williams, who was our president, led a team of 100 lawyers out to LA to investigate and create an after-action report on how the police responded to the civil disorders and where mistakes were made and what could be learned. And that isn't a bad model at all, but it does require a sort of significant event for people to really focus on it. And then we've had things like the Christopher Commission, the Knapp Commission, the Mullen Commission that has looked at all kinds of problems in policing and whatnot. And then the other approaches to use supervision and to rely on prosecutors to further the investigation of the police and to kind of check for error. But all of these, as has been mentioned so many times today, have really been focused more on failure, on punishment, and on blame. And what I like to really think about in terms of the police culture is that, again, as people said this morning, the old caveat that to err is human and to forgive divine. I'd like to say in police culture, to err is human and to blame just fine. It really is. I mean, that's what you do, and that's what these systems do. So in terms of the culture, to kind of move through, I think that what we have to start to do is look at how the past approaches have really fallen short. And instead of assigning blame, we ought to start looking for opportunities to improve on the model that assumes that the culture has a lot of bad apples in it and they're going to do bad things. And this has been talked about in terms of prosecution as well. I don't think it's the right way to look at this. And Kim Rossmo talked about in his book back in '94, the Canadian Police College, and he talked about that because he was a former Vancouver cop before he went to Simon Fraser University. But he said that they came up with a model at the Canadian Police College to come up with a major case management system for analyzing investigations. And they went through planning and, having straight goals and being very clear about that, using resources effectively. But then things like note-taking, which we really don't put that much emphasis on in policing. And I mean, we have to do it, but we don't put a lot of emphasis on it being formatted in a way that is consistent. Another anecdotal finding from our study in Austin was that we noticed that in some cases, a suspect was put into a lineup, and there was really nothing in the case file that made us think that there was a reason why that person was put in the lineup. In fact, in one case, the guy's name was Jose, and of course in Austin, Texas, there's a lot of Jose's, and on that basis alone, it looked like that was why the officer brought this one guy in, because he knew a guy named Jose in that general area. But he probably didn't know that there was 350 others in that same neighborhood named Jose. So that's not to say that they necessarily didn't have a justification for why they put the person in the lineup, but it was surprising to me that there wasn't a policy that you have to articulate that in writing and be able to actually follow through in that way. So these kinds of things are really quite important. And so to wrap up, I want to just talk about a couple of new initiatives that we're doing at the Police Foundation. And by the way, just for background, the Police Foundation is a nonprofit, nonpartisan organization established in 1970 with the sole mission of improving policing. And we do that to this day through empirical research and scientific endeavors. Sometimes we work to translate those to practice through policy or training. But one of the things that makes us uniquely situated in the world of policing researchers is that we're independent. We don't have members, so we don't represent chiefs, we don't represent unions. If anything, we represent the broader community as well as the citizenry. So we're able to do research without having to worry about what the results might show and who might get upset about that. And that's a real advantage for me and why I've probably stayed there for 20 years. But one of the things that we're starting to look at, our president, Jim Bierman, who is bumping about the country right now, just very active in trying to come up with solutions to many policing problems. He and I have discussed at length the issue of messaging. And we think one of the problems here is simply the messaging that's used in general. You have to remember, in policing, there's a culture, everybody talks about their different cultures, and but they're not that different. But the culture in policing is one generally of suspicion and, in which case the issue is really about, being open and allowing officers to be looked at in a positive way. And what they hear when they hear wrongful conviction is, you guys messed up, we're going to hit you upside the head again. And this is what they hear. And they see the media accounts, and it says the police are always to blame, and we're the bad guys, and all of that. And some cities, when I was in Detroit, I remember one officer saying, when we go into certain communities, mothers grab their children and say, be afraid of him, he's a cop, he's going to only do you wrong. And so this is the kind of thing they're barraged with. So we have to really think about remessaging, and remessaging around things like, it's not about wrongful conviction, it's about the promotion of improved practices. We have two efforts underway with the Department of Justice through the COPS office right now. One of them is called Promoting Investigative Integrity and Excellence, and that project is designed to use a simple kind of case study approach to looking at cases that were catastrophic and those that were not, or there were averted errors, or what we like to call near misses, as so many industries have called them. And George Carlin, by the way, hated the term near misses, because those of you who even know who George Carlin is, he's a comedian. He said there's no such thing as a near miss. If you nearly miss, then you hit. So you either have a near hit or you can say a miss. So he hated that terminology. It's not really the right terminology, but what we really mean is an averted crisis or catastrophe. And so as we move this project forward, we're going to be looking at cases with prosecutors and with police, and looking at ways to take those lessons and figure out a way in the culture to shift it so that we can be a non-blaming kind of community where cops want to come forward. That being said, our other initiative underway, which I'm sure Tommy, is really central to, is the idea of developing a near-miss database. And the COPS office has provided some seed money so that we can begin to do that. We've established some parameters with a working group. We're going to start to reach out to other policing organizations and unions and whatnot to try to establish buy-in so that people can voluntarily report on data fields that we can then mine and analyze for research purposes to try to improve policing, which is what we're really about. So we've got a number of these things underway, including finally an effort by Emily Owens, who's a professor here at Penn in economics and police. We're now starting to work more with economists and other types of scientists, and we're looking at, in Seattle, procedurally just ways of dealing with officers in your agency through supervision, as opposed to only looking at procedural justice as something that we want to ensure in communities. If you want cops to act in procedurally just ways, our hypothesis is that you have to act procedurally just with them in your supervision of them. So these are just some of the things that we're starting to do to kind of change that culture and to start to move it forward. So I really appreciate the opportunity. Thank you to the Quattrones and to everybody here, John especially. Thanks.
Yep. I too want to say how honored I am to be here. Thank you, John, for including me here in this incredible event. And I have this feeling that if we all just stayed here together, we could really, everything would be perfect if we just all create our own little world here. But alas, we have to go outside, and we've been
Stay as long as you want.
Well, we've been talking about errors and resistance to recognizing errors, and I think that one of the reasons for this resistance in criminal justice as opposed to other fields is really a general lack of oversight. And in that sense, I mean a basic lack of public knowledge of how our criminal justice system is working. So if I said to you, where you live, can you tell me where the good public school is? You could tell me. Now, you could probably even tell me a couple of different ones. And if I said to you, well, where's the good hospital? You could probably break it down by specialty. And we know these things because in education, there's teacher-student ratios, there's graduation rates, college admissions, and for hospitals, there's all sorts of data, continuity of care, survival rates. But if I said to you, okay, how does the criminal justice system work in San Francisco? And how does it compare to Boston and Manhattan? You would probably have no idea, and that's because even the people in this room who know more than anybody and who are the criminal justice system, you would probably couldn't really say how they compare. And that's because what we haven't done yet is created a system of measures to compare how criminal justice works on the county level. And what my organization is called Measures for Justice, and what we're doing is creating a new set of measures, and they go from arrest to post-conviction, and they measure every aspect of the system: prosecutors, public defenders, judges, defendants, and by defendants I mean every defendant who goes through the criminal justice system. And the reason why we're doing the whole system is really, in terms of innocence cases, when there's a wrongful conviction, generally when you do the diagnosis, it's not one bad apple, right? There's a constellation of people who made it happen. So you want to look at the whole constellation. And we do it county by county. Why? Because justice in America really happens on the county level in 3,000 counties. So now I'm going to take you to one county. It's one I visited in my book. It's called Quitman County, Mississippi. It's about an hour and a half south of Memphis. And I was sitting in the office and I was talking to the court clerk, and her name is Miss Wiggs. She had a helmet of white hair, which is really funny that her name was Miss Wiggs, but and she had this list of cases above her desk, and it was handwritten in teeny handwriting. I said, "What are these lists that you keep taped up?" And she said, "Oh, these are cases that the prosecutor was supposed to bring to court last grand jury. And by law in Mississippi, everything has to be presented to grand jury when it's charged in a lower court. The prosecutor can say, you know what, this isn't a very good case, don't indict. But by law, it's the people who have to decide." And I said, "So what happened to these cases?" She goes, "I don't know. Every term of court, he only presents a few cases. And people call and say, what happened to my case? And what happened to my case? And I don't know." So I said, "Can I use this list?" So I took the list and I used it as a roadmap to find out what was going on in Quitman County. And I found that entire categories of cases had disappeared. For example, I met this woman, her name is Sharon. She had been beaten up by her boyfriend. He took a tire iron and just hit her and hit her and hit her while her daughter and niece watched from inside a locked car. And there was a hospital report. And this is Sharon, and you can see here the photos of her being beaten, of what she looked like. These were in the hospital report. And she didn't know why nothing ever happened in her case. She never went back to live with her boyfriend. She went immediately and lived with her mother, who had scooped her up right afterwards. So I said, why wasn't this case prosecuted? I talked to the police. I talked to the sheriff. I couldn't figure it out. So then I went back to Ms. Wiggs, and I said, Ms. Wiggs, when was the last time a domestic violence case was prosecuted here? And she said, let me think about that. So she looked in her computer. She couldn't find anything. And then she looked back in these big bound volumes with like gold writing on them, and she said, there hasn't been a domestic violence case prosecuted here in 21 years. And so I went to the prosecutor and I said, do you realize you haven't prosecuted a domestic violence case in 21 years? And he said, has it been that long? So what Measures for Justice is doing is we're looking for these invisible patterns of problems out there. We're trying to make the invisible visible. We were founded in April 2011 to create what we're calling a national infrastructure for measurement in the U.S. So insiders and outsiders can see how a county is doing. And this is our secret sauce. What we're doing is we're collecting individual level data, and we're performing analytics. And the idea of analytics is that any one measure can be dismissed, but we're trying to relate the measures to each other to come up with concepts, or what we're calling dimensions. So there's a new neutral language that people can talk about the criminal justice system. And the third thing is comparing the results. And in our initial pilot in Wisconsin, for the analytics, we came up with these 4 dimensions. And you can see that they're how timely the system is. The second is how strained the system is in terms of caseload imbalance. And the third is whether the system is optimizing resources. How did we get these? What we did is I put together a data council of people who really care about criminal justice measurement on the local level, and one of them is here today. And I know there are a lot of great district attorneys in the room, but John Chisholm, who's right over here, is really an incredible person. The access he's given us, I just want to say I'm grateful to you, John, from beginning to end. Anyway, so we put together this data council, and they came to where I live in Rochester, New York, and we basically argued for a day and a half, and we decided to come up with measures that we thought there would be data for in the United States. And the problem is, right, 3,000 counties, 50 states, where's the data? And what we figured out was that we could come up with measures, and we'd just try and go see if we could get the data. Then what we decided is that the measures really had to be neutral. And so here we came up with these 3 goals. Why is this happening? Yeah. Whoops. We came up with these, here they are, the 3 goals, and they're neutral, which is enhancing public safety, promoting fairness and accuracy, and promoting, improving fiscal responsibility. So there's supposed to be a little something for everyone. If you really care about saving money, if you really care about law enforcement, that's the idea. Anyway, we came up with these 50 measures, and the first thing we tried to do is do the easiest thing first and look for federal data. Was there federal data out there that we could populate our measures with? And in fact, we couldn't find much. We basically found about 15 measures, and here you can see this is not so great. It's old, it's 2004 data, 39 counties. It's interesting, Los Angeles' bails are 35 times as high as Broward County. We showed this to some people at the Department of Justice. They said, this is really interesting. We'd love to go see if you can find it on the local level. So we went to John Chisholm. We said, John, could we do a pilot here in Milwaukee? He said, of course, come and do it, and we'll help you. I'll get you the prosecutor data, I'll get you the public. I said, okay, we're coming. So we came, we partnered with John, and this amazing thing happened, which was we looked and we got all this local data, and there was a state database there, and we paid a minimal amount of money for it, and we translated it, and we ended up getting data for about 70% of our measures. And we came up with one measure, especially for Sharon. So here you can see, this is the domestic violence incidents identified in the emergency room versus the number of people prosecuted. And so you can see as you're going along, but at the very end, you can see there's a little black bar. That's actually Milwaukee. And they prosecute 4 to 1 for every 4 domestic violence incidents identified in the emergency room. They prosecute 1. And that's basically an average. It's mean. It's pretty much that way across the whole state, except for these 4 counties. The last one, we didn't include the name of it here, because we actually haven't told them yet. They should know before everyone else does, but yeah, it was 70 to 1. So Sharon would be one of those 70. And the interesting thing is that when I talked to the Mississippi prosecutor, I told him, that he had him prosecute domestic violence. He said, the reason I don't prosecute is because they're not good cases. You can't win these. The woman always recants. And I'm under strain. I'm so overwhelmed. I have such an enormous caseload. How can I begin to prosecute these cases that I'm never going to win? So the idea is that he's under strain. So here in that county, you can see we created dimension for strain. And you can see here that we correlated 3 of the measures. The 3 that we correlated were attorney caseload imbalance, defendants pleading guilty to a lesser charge, and cases with a speedy trial motion. The idea is that as prosecutors' caseloads increase, defendants are more likely to plead guilty to a lesser charge, and the defense is more likely to file a speedy trial motion. And you can see here across the state how the counties fell. The one that had the 70 to 1 ratio actually was not strained. Milwaukee is strained, and in fact, John told us this really interesting thing that as of now, there's really not a way for him to tell the State Criminal Justice Coordinating Council how strained they are, and he's been saying that for a while. And here you could actually see this is where Milwaukee is on the left-hand corner. You can see that there is this heavy strain. And that's because that's where the most industrialized part of the state is. I just thought I'd touch on one last measure, and then I'll wrap it up. Am I okay on time? Which is, this is part of our optimization measure, when that's the idea that there must be tools that we use that everybody can agree on, that save money, that promote fairness, and also help public safety. And one of these is deferred felony cases. And you can see here, there's Milwaukee County has 6,000 cases, County E, County D, County B. Those 3 are actually, E, D, and B, are all in Wisconsin. County A is a county outside the state. And again, we're not mentioning what they are here because, we want them to know first before we tell the world. But anyway, the idea is that cases deferred here, you can see, by a case deferred I mean where the prosecution makes an agreement to put the person into rehabilitation or commit a series of processes, and then they don't come back to the system within 6 months. That's a successful deferral. And you can see here that Milwaukee defers 7%, and County B, look at the last column, they only defer 2%. And what the interesting thing is the 2% county, County B, has only a 22% success rate, and Milwaukee has a 93% success rate. So what would happen if County B talked to Milwaukee, which is, they're about 2 hours away, and they have a conversation, and the idea is for this 22% number to swell. And put in the practices that Milwaukee has worked so hard in with so many of its evidence-based practices. Craig mentioned return on investment for $60 per day for incarcerated individuals. What's the return on investment on that? What's the return on investment of creating a national infrastructure of measurement? Think about roads. What's the return on investment of creating national roads? That's the way we like to think of this. The idea is that if we put the resources in now to do this, there'll be a different world in 10 years when we can actually look at what's happening in local criminal justice systems across the country. Thank you.
Okay, we've got about 7 minutes or so, if we would like, for questions. Anybody have any questions for the panelists? Can you use the microphone, Barry, because we're recording? It's up in the... Sorry.
So in terms of data collection, I have a simple question for Amy, Jeff, John, Karen, whomever. Just take the issue of eyewitness identification. Can any of you tell me how many cases where crimes are committed and eyewitnesses, whether they're the victims or the witnesses themselves, are engaged in an identification procedure, whether it's a photo array, a live lineup, or a show-up, then how many of those cases ultimately result in arrests, and how many of those cases go to trial or result in plea bargains, and among those from trials, how many of those have hearings? Is there any way to retrieve that data that you can think of?
We'll talk after. I'll get,
You really
we'll put our team on it. I mean,
You really think you have that data?
oh, I don't know. I can't even begin to answer. I mean, in terms of, I don't know, eyewitness lineups?
Yeah.
That's beyond, what was in the kind of databases that we're examining, but I defer to Jeff, who.
Yeah, and the answer would be, I could probably speak for all the public defender offices in California. No.
I can't find anybody.
We don't have a friggin' clue. And we
I
should.
I can't find anybody that's collecting data in that kind of systemic way. And, what we do know about eyewitness identification is from archival studies and everything else is that 1/3 of the time witnesses will pick a filler. We know that. We know an awful lot, as so many of the people in this room know, about the science in terms of how to do best practices that will maximize what we think will be reliable results and minimize unreliable results, but we don't have any kind of concept of how to count. So you get a sense of the dimensions of the problem so that you can walk in to a legislative agency and say, boy, we really need some money to devote to this problem to make sure all best practices are followed, because this really is involved in X number of crimes. Mm-hmm. I mean, because there's that whole quantity of crimes that are committed that don't result in arrests, and then if you talk about those that actually do result in identifications and then arrests, how many hearings are there? How many hearings we don't even have numbers for? So when courts are sitting there going, oh, I don't know if I want to follow this landmark decision in New Jersey or in Oregon or somewhere else because I'm going to have too many hearings and I can't have people testify, there'll be this, tsunami of cases. We have no data on this. Now, as good as it is to start picking at some of these issues with respect to strain, and as terrific as it is that you can do caseload weighting, because I'm sure that means that everybody, whether you're a prosecutor or a defender, you're all doing timesheets, right? So that we can get real accurate measures. Is that right? You're all doing timesheets?
Hey, Barry, we have some data in Dallas County.
You have what? Some what?
Some data on eyewitness identification.
And as a matter of fact, that would be great to see.
Well, I mean, it's simple.
But I mean,
I tell you that before we went to the double blind system, the data was that of the 33 individuals that were wrongfully convicted, they were wrongfully identified.
That data I know.
So,
we just had this seminar and we brought together people in different fields, like healthcare, the environment, education, to talk about the early stages of when they were doing their measurements. And one of the things they said was that putting the data out there creates a response. People say, no, that's not exactly right, and you measured the wrong thing, and it creates a cycle. So the idea is the more of this that we do, the better data we'll eventually get, because people will start collecting things that they actually want. So the idea is that if you just keep on doing it and putting it out there, that it will ultimately increase.
Well, I guess I don't mean to be facetious about this, but it is quite frustrating that when you get to some of the key areas of reform that we actually know something about, scientifically, and we can do something about, there should be some systematic way to collect this data, to do that in a way that, in I think other fields they do. because I don't know how many times this morning I heard things about, you can't manage what you can't measure, you can't count anything unless you know what you're counting, and so I just figured I'd throw that
And Barry, one of the real issues with that is I think we could, in policing, begin to identify how many cases actually had lineups in them and how many of them had arrests in them. But the black box of this is really to get at the cause and effect nature of these things, because just because there was a lineup and there was an arrest doesn't mean that the arrest was due to the lineup. It could have been due to a combination of factors. And so you're absolutely right in questioning, can we get at the data? The real question is getting all of the right data fields and then not making over inferences about them by, statistically modeling it correctly so that we can make predictions about what that means.
So I think in a sense, Karen, you're actually, Amy's starting at the beginning, Barry's frustrated he's not at the end, and you're expressing the cyclical process that Amy says is going to happen, where we have to start with something. I think we can all agree that criminal justice, Terror is Human was 1998, the aviation safety stuff was 1974. In 1998, they said we're 15 years late, we're 15 years behind. We're 16 years behind that. That's like 147 years late.
I guess
and so we're going to need to go through this process, but you're exactly right to keep demanding that we be at the end game, because that's how we're going to get there faster.
I don't know if I'm demanding the end game at all. What I'm just simply saying is you have to, when you're putting together police reports, which are then going to be electronically stored, right? How can you not have police reports that will check off? This was a photo array, this was a live lineup, this was a show up, right? And then you can track the case through the system. Now, we've learned this in crime labs. Yep. That, the biggest problem we have in crime labs is that we get on yet another crime lab scandal where they're either there's either fraudulent crime lab stuff where people are dry labbing or they're, not doing it, or we then find that there's a forensic assay and there's more and more of them coming where we realize that the science is wrong and we have to go back and look at the old cases. Well, how can we find the cases if the lab accession number is not tied to the case number, right, in the court system, so we can go back and find the cases? Now, this is what we encounter all the time. So there doesn't seem to me to be any excuse at this point in time, if we're talking about systems, to simply put together, whether, we have now LIMS systems, these laboratory information management systems, where we can begin to track it. Don't we need to have this group of people start thinking in terms of what data do we need so that we can begin tracking that electronically through police reports into the system? That's my...
And that's definitely very key. The other issue is, as most of us that work at all with the police know, that there's no national standards. And so we've had this discussion with Tommy because his organization is working with us on this near miss issue. And the question is, all of the immunities that are granted in the medical system and in the fire system and whatnot are obviously not going to be there for police, so we have these other issues surrounding it. But the data, it's a question of consistently capturing in that, and there's nothing that you can do to impose upon an agency to do it, but you can encourage them. And that's, I think, what we're going to try to do by actually getting relevant data fields, which is what you're talking about.
Karen, there is two areas that you can go to get information that is available, publicly available. It's suppression information, suppression of those cases, and reversals. So in both those areas, that information is going to be available, and collect that data. Lots of times the public defender's offices will have that information. We've used that before. And you can grab that, and then that'll help you identify some of the cases. It won't get all of them, but it'll get you started in the right direction.
Yeah, next question, thanks.
My name's Corbin Gardner. I work with Witness to Innocence, which is a national organization. We work with folks that have been exonerated from death row. My question is for Jeff. Jeff, thank you for your presentation. At least you convinced me of the value of a checklist. I look forward Monday morning to write myself a big old checklist. But in terms of these checklists, is there any effort to make them widely available to public defenders across the country? Maybe if the answer is yes, is there an initiative to inform people of where these checklists can be found?
Yeah, thank you for your question. And the answer is yes. We have about 50 checklists that we put together, and I would imagine that we're probably going to double that. The answer, we're not trying to create a million checklists, but we want to have checklists that cover the most common situations. We have things like how to prepare a client to testify, how to file a mental health writ. And obviously, each jurisdiction is going to have to tailor the checklist to their practice, but in many cases, it's universal. So we are making these available. I told John I was a little reticent to make them available here because, we don't want to blast them out to the world. We, in the past, have limited to people in the public defense community, defense attorneys. But certainly, I'd be happy to share with you and anyone else who would use them in their practice. And thank you for your work.
Okay, if there aren't any other questions, then what I'd like to do is we will reconvene in 10 minutes for the final panel of the day, and I want to thank all of our panelists for showing us what's going on in criminal justice.